Good morning, everybody. Hello. Hopefully, I'll give everyone a couple minutes to come in. It looks like they're still connecting. Let's see. Okay, I'll just give one a couple minutes. It looks like there's still a couple more people that are coming in. Okay. Well, we'll go ahead and get started now. We're going to do something a little bit different today. I'm Regina Campbell from the Campbell Law Group, the managing attorney. And normally we have a little bit of presentation form, and you can follow along as I talk. Today we're going to try something a little bit different, a little bit more conversant. Today you can see me a little bit more and get an idea more of how passionate I am about this particular subject. And, just maybe see if we get some more interaction also from the group. We are here today on a webinar for the Campbell Law Group that is sponsoring why a shareholder or partnership agreement is necessary. So we're going to talk about a couple of reasons, actually, particularly what we've divided out is into the 5 Ds as to why it's necessary. There are other reasons also that potentially a buy-sell agreement is necessary. And then today we're going to use a little bit interchangeably the term partner, even though a lot of times partner refers to partnership. And then, of course, members refer to LLCs and shareholders, refer to corporations. I'm going to use partner sort of interchangeably just to talk about your partner, so your business partner. So it does apply, just so you understand, most of the provisions that we talked about today, with some exceptions and nuances in certain laws and partnership and maybe some areas of corporation. Pretty much a buy-sell agreement or the provisions that are in a buy-sell agreement are interchangeable between LLCs, corporations, and partnerships. Overall, it's the concept behind buy-sell agreements. So in other words, a buy-sell agreement is, I like to call it, it's sort of the exit strategy within a partnership. Whereas maybe the operating agreements is either a pre or a post-nuptial agreement between the partners. So we're going to talk about the very, sometimes I'm going to point out the differences between operating agreements, provisions that might be in those type of agreements versus what is in this specific agreement, these buy-sell agreements or exit agreements. And I'll give you some, particularly focusing on the exit agreement right now, but I'll give you some examples of what might be in an operating agreement that is also very important as well. So let's start off first here. This webinar, like we indicated, is going to focus on, the 5 Ds. What are the 5 Ds? A dispute, divorce, debt, disability, and death. Okay. Sounds horrible and ominous, I understand. But this is part of the reason why a buy-sell agreement is necessary, in the same manner in which often people will do probate documents, wills, trust. It's to plan for if something should happen, to avoid any defaults that exist in law, basically, or avoid some unintended consequences, some situations where you're defaulted to what the statute might say, or you're defaulted to be in a situation where you're having to deal with either your partner's estate, your partner's spouse, children, potentially a creditor stepping in the shoes of your partner. So these type of agreements are going to help avoid that unknown. And to some extent, not everything can be controlled in life, but to some extent, try to lay out what happens in the event of these circumstances, which I call the 5 Ds. But let me take a moment. I also want to give a shout out to all of my Star Wars friends. I have brought Darth Vader balloon in today. I want to make sure I say happy, May the 4th be with you. Some people probably don't realize, but I can be a little bit, geeky. I love Star Wars. I'm also a Marvel fan. So to shout out to all of my Star Wars fans, the fans that are out there, they're also watching. May the 4th be with you. Also, it's actually apropos to some of the discussions. So as you can probably tell, I brought in Darth particularly because he is going to represent somewhat of the nemesis in this conversation today. And hopefully you'll find it enlightening and probably instructive as well. So basically, let's start off with dispute. Okay, what is, how would a buy-sell agreement help you with a dispute? So when I think of dispute, you think, okay, you're not agreeing with your partner about something. It might be something small. The problem becomes not when it's something small and day to day. The problem becomes when it's larger issues that sort of the communications between the partners would temporarily break down, or you guys are taking opposite sort of approaches to things. So in other words, maybe you're not happy with the way the business is going. Maybe there's poor business performance, in which case you think that the business should go in another direction in order to improve its performance. Your partner may think differently. May think, no, leave it alone, it's perfectly fine. Management styles can be different, which leads to not being able to get along and the creation of a potentially toxic environment that you guys did not foresee during the honeymoon stages when you created the business, because businesses are very much like marriages. I mean, they don't have the family aspects and the personal sort of or romantic aspects, but they very much are about pooling resources together and making decisions between you and your partners, whether it's one or many partners. And we're going to talk about how the dynamics can change depending on how many partners you have. But maybe you don't get along. Maybe you have different business styles. The partner might not be pulling his or her weight, or taking and doing their responsibilities as originally had been discussed. Now, some of these can also be better handled if they're in an operating agreement. So, in other words, and by the way, buy-sell provisions can be put into an operating agreement, but this is if you don't want an operating agreement, to have these provisions in them, or you don't have one, you just want an exit strategy. But for instance, an operating agreement can help when a partner's not pulling his or her weight by defining what they were supposed to do. As part of your understanding between each other, what were you supposed to do? Were you supposed to do the management and the accounting? Were you supposed to do the sales? If you're defining those roles and those responsibilities in an operating agreement, it's much easier to potentially enforce the agreement or show that the other party is in breach of an operating agreement, because you can say, hey, listen, you're responsible for accounting, or you're responsible for sales. You define those duties and responsibilities in the agreement, and it makes it a little bit easier to hold someone's sort of feet to the fire. When it's not defined, the partner can say, that's not what I agreed to, or I am doing this here and there on this day, on Monday and Thursday, every other week. And then in which case there's nothing that has indicated that person's part of the responsibility and the understanding between the partners was that they had to put in this effort and this work. That becomes particularly important for other reasons as well. If the person or the partner is not pulling their weight, you may have to hire their other employees to potentially cover that weight in which you anticipated each other doing this. So you might be taking a salary, each one of you, and the person's not pulling their weight, and now you have to get another employee basically to do the other partner's work, which is going to be reducing the profit. So bottom line, coming down to practicality, that is, I'm sure, not what was intended if you guys had talked about it from the beginning, and made it clear that the presumption was each one of you would be putting a certain amount of efforts and work. Now, sometimes there are silent partners where they just basically put in the money and the other partner is going to run all the operations. It's much better if that is in an operating agreement, just so that it's clear, so the passive investor is not running the risk of someone saying they're not pulling their weight or doing their job. The passive investor may also have another business, may have another career, and this is just sort of an investment tool or instrument for them, not necessarily a day-to-day lifestyle in which they anticipated to live, or do this type of work. So in a dispute, though, in a buy-sell agreement, what if you want to leave? Okay, how can you leave? The statutes, depending on the type of corporation that it is, doesn't easily just let you walk away. For instance, in LLCs, and particularly if you have an operating agreement that doesn't permit it as well, but often you cannot just withdraw from the company. It must be permitted and or agreed to between the other members. And if it's not, you run the risk of additional penalties and issues. So if you put into a buy-sell agreement provisions that allow you to say, okay, in the event that I want to get out, you can do either what I call it put. You can say, okay, I want you to buy my interest potentially at this expense, and we're going to talk a little bit about fair market valuations and valuing your company. for the purposes of the buyout. Basically, you could say, you could say, okay, I want to buy you out, or you buy me out of this. We can't live together, so to speak, anymore, right? We need a divorce. We can't work together. We're not getting along very well. Or it could be that you decide to move on to something else, and you just want out of the business and out of the responsibilities. You could put the provisions into these type of buy-sell agreements on how you do that. So it's not a question of going to litigation and requesting permission to get out lawfully, or to withdraw from an LLC, or potentially, get out as a shareholder, which may always not be so easy. The other thing is also sometimes depending on, this is where numbers matter. So in other words, if you're 50-50 partner with somebody, and for instance, I like to just use the analogy, if your partner says we want to do black, and you say we want to do white, what do you do if you're diametrically opposed and neither one of you want to agree? If you're 50-50, you're in a deadlock position where neither one of you can technically act without the permission of the other. That often can lead to litigation, and shareholders very expensive, lengthy, destroys the business that you may have created in its valuation, sends a message to the market of a shaky business not on solid ground, potentially makes it harder to sell. So you can have a deadlock provision in that what happens if the parties cannot resolve their issues and their differences, what happens? So that kind of takes the sting out of the unknown, and it makes it clear, if this happens, this is how we're going to resolve this issue so that we don't destroy the company or its value, of everything we put together. So, I mean, the difference is if you have three, partners, and you're each, let's say 33.33, right? Shares, owners of the company. Keep in mind, depending on the operating agreement, and if you don't have one, it's going to default to the statute of majority sort of interest, so to speak, depending on, assuming it's not a major issue, such as maybe, adding stocks, or, valuations, or selling the company, something that requires a higher percentage vote than majority. You can be outvoted all the time if it's a majority. So you become a minority, and the other two partners could potentially take over a company and take it in the direction that they want, including removing you as an employee. So these are things you want to keep in mind, when you're setting things up, and that's also something that could be in an operating agreement and also in a buy-sell agreement. So something to keep in mind. It's a little bit scary, but it's much better to have these things in place than not to have them in place. So the next D that we're going to talk about, and by the way, the dispute is, I forgot to mention at the beginning, but basically imagine yourself, the worst case scenario, your partner is Darth Vader. Unreasonable, not very kind, compassionate. It's much better to have these type of provisions in place, I would say, than to basically go to, court with Darth Vader. Trust me, it's not fun. Or Darth Vader type, shall I say. So divorce is the other D, okay? Everyone, unfortunately, most of us can relate to it in one manner or another. Even if we haven't been divorced, we've seen some, family members, friends go through divorce, and it's never pretty. There are a couple of scenarios here you want to think about. I mean, a lot of times you're going through a divorce yourself. Well, if you own the company with your spouse, an agreement as to what happens during a divorce, to the company itself would be very handy and would eliminate the guessing game of the court potentially having to be called upon to decide what's going to happen with this company. Further, particularly in Florida with Thompson v. Thompson, the courts are unfairly the party that does not keep. Now, this is assuming that both parties are owners of the company on record, not necessarily that the other party has a right in the company due to the marriage, but it's not actually a record, a stockholder, shareholder, member, and so forth. But if you are together shareholders in a company, if you're married and you go through a divorce, it would help for valuation purposes, because potentially you might avoid, the court applying Thompson v. Thompson, which is actually not fair in determining valuations for the party that does not keep the company. It has a tendency to be lower than what you might normally get under a market value analysis. So it's probably better to have one of these agreements also in place if you do own a company together as a married couple. If you're not married and you are, and you're partner with somebody else and you're going through a divorce, part of the problem is without having a buy-sell agreement, you could potentially have a court, depending on circumstances. Normally courts try to keep the party that owns a business usually keeps the business, but there are circumstances in which you may have fraud or issues going on. where the assets have been dissipated, and the courts, in certain circumstances, may have to divide the company up or your particular interest. If you have a partner and you don't have an operating agreement or a buy-sell agreement that limits the sort of a third party's rights to come in, you can potentially have an issue where your partner's shares are being given to the spouse. Not a very pretty situation. You want to have a limitation where, in the event, either by operation of law, creditor, which we'll talk a little bit about, a debt, or a spouse were to inherit the shares of one of the parties or partners, you want it where it's where they're limited to economic benefit only. They can't step in the shoes of their prior spouse. They can't vote. They can't run the business, basically. More ideally, you would have a first right of refusal to buy out that person's shares in the event this occurs. And you map out what those prices will be, and you potentially give yourself, how can I say, funding methods. So in other words, in the event you have to buy out the other person's shares or the other person that inherited, so to speak, the shares, whether by death, divorce, or by operation of law of a creditor issue, you're given the right to buy their shares back on a certain term, which might even include a promissory note for paying part of this, part of the valuation of those shares that make it more affordable for you to make sure you actually can buy them out. These little tools that we can use in order to help in this type of circumstances, and they should be used, but they have to be put into an operating agreement or into particular a buy-sell agreement, provision, or agreement. Okay. Another example is your company might be brought into divorce proceedings. You hear some of these nightmares where the other spouse is basically, I'm going to destroy you and your partner, and I know you're hiding money there, and you have a girlfriend at the business. I'm going to rip it apart. I'm going to bring the company in as a third party, and I'm going to be Darth Vader. I'm going to make your life miserable and your partners until you give me what I want. Well, if you have a provision in an operating agreement or a buy-sell agreement that limits the partner's, the partner's spouse's sort of recourses or resources or remedies against their spouse's interest, you avoid those type of issues and you can limit them. It doesn't mean that they're not permitted to discovery as to the financials of the company, but it does mean that they can't come in there and try to say this company may belong to me in the future in a divorce, therefore I can come in here and I can sort of wreak havoc here and throw decisions, into turmoil that have to be made on a day-to-day basis. So this is just something to keep in mind. Also with debt, unfortunately, you could have creditor issues in which a creditor, or you file for bankruptcy too. That's another circumstance. A bankruptcy court has to do something with your particular shares, depending on the type of bankruptcy chapter that you file. But you're going to basically be subjecting your shares to the bankruptcy court, the trustee, to kind of to do what they believe is necessary in the proceedings. So this is another example, for instance, in bankruptcy, in which you would want a buy-sell provision in place so that you can say the first right of refusal. So in the event of a bankruptcy, the other partner has, or the company has the right to immediately purchase the shares of the other party for fair market value. You might determine the methodology that's going to be used in the agreement for fair market value. And in which case you can structure, if you have put in place a promissory note that could be used to purchase the interest, or the terms in which you can do so, you can try to keep that out of, the bankruptcy court's purview, not because you're denying the bankruptcy court any of the person's shares or rights to their assets to restructure them, just you're basically, creating a preemption where this is what's going to happen in these circumstances. Same thing if you get a creditor, if your partner has a creditor. They don't necessarily have to file for bankruptcy, but they go to lien that partner's and other partner's interest. They're going to look to actually foreclose on that interest and either now become the owner of the company or potentially try to force the sale of the company because they want to get the asset out. They want to get the money back. So by putting together a buy-sell provision, you avoid that. You set the terms on what happens in the event a creditor attempts to do this. So you limit the havoc that could be created, the litigation, the fighting, the protecting of someone's interest, including the other partner's potential interest. So that is also debt. That's debt in bankruptcy. And creditors. So for instance, you could hopefully you're starting to see now the benefit that these type of agreements that can have, and the added element of stability. That's very hard to find often in life and in business, that at least you know what's going to occur under these circumstances that are often life-changing. So one of the other examples is also this disability. So disability, whether it's short-term or long-term disability, this is, you can define these things in the contract, because of course someone may become disabled for a short period of time, or the partners becomes disabled. You basically want to say what happens in that event. If it's short-term disability, maybe you and your partner have talked about buying a disability insurance policy that would help help you during this time, maybe supplement your salary, or potentially supplement what the company has lost as a result of you not being able to work during that time. You might say, okay, short-term, not a problem. We're not going to force the sale of anybody's shares. But for instance, long-term or permanent disabilities, that might even include being found to be mentally incompetent. You can define the terms on how long that's basically, let's say it's either been disabled for more than 12 months or been held to be found to be mentally incompetent. This is what occurs, okay? And during that time, the company may want to say, well, we want to force a buyout of that person's shares, particularly in professional associations where that partner's skills are needed. It's not as if you can just go get another manager potentially to fill in sort of the spot of that partner. In addition, that's an additional cost as well. But so it might be particularly important to maybe bring another partner to help with that responsibility, and in which case the company cannot afford to continue to pay out either distributions or a salary to a partner that's not able to contribute in the same manner. It may, in some occasions also, it may not be fair, right? The person's family would continue to receive distributions and salary without doing some of the work, and the other partner technically would have to shoulder the additional cost and work. So, but there's times, of course, that partners will say, I want to help take care of you for a little while. We're willing to do this for a certain amount of time. The disability helps at least define what occurs during those circumstances and what the parties' understanding is between each other if this occurs. The same thing with the death. Our fifth D for the day. Death, basically death of a partner. I mean, it's very difficult on everybody, of course, and particularly the partner's family. But what occurs if you don't have a buy-sell agreement? In the event of a death of a partner, it's going to become a probatable asset, which can be a mess for it to go through probate court, potentially through the process, and even more difficult if it turns out that your partner died intestate without a will or direction as to what happens with his or her interest in the event of a death of the company. It also becomes an asset of the estate. So technically, whether they order the sale of it to court, or the new estate members or the beneficiaries now becoming new partners, well, you may not want to be partners, with all due respect to someone's wife, your partner's wife or husband. They may not be apt, or, you didn't choose to go into business with them. They may not have the ability to further conduct the business with you or run the business with you. And a buy-sell agreement can help avoid that, where you put the provisions once again in place that the company or the other shareholder has the right to first buy that partner's interest from the estate. You set out the terms, you set out the use of potentially a promissory note. Here is where also the use of life insurance would be helpful. If the company owns a life insurance taken out on either partner's sort of name, in the event of a death, the life insurance can help purchase that partner's sort of share from their estate and buy them out within a buy-sell provision, and that's very helpful and actually very usually tax efficient as well. Something you should talk to your accountant about a little bit more. So hopefully you're seeing right now some of the benefits of a buy-sell agreement. Maybe you're starting to think about even circumstances and where it could be like very important to have. You're probably even thinking about other circumstances in which it can apply. There's many different circumstances in which it can apply. I've given you a couple within the 5 Ds just to kind of, get you thinking about these things and understanding the importance of it and what can be done to help mitigate some of these risks and issues that can come up within a partnership. So I don't know if anyone has any questions. Hopefully that's been helpful. Anyone have any questions that I might be able to answer? Okay. Thank you. This is Ricardo, who's bringing me questions. Okay. All right. First question: what if you sign a shareholder agreement and the shareholder still defaults? Okay. So a shareholder agreement can be, remember we talked about a shareholder agreement is usually what's found in a corporation. And it could be similar to an operating agreement and a partnership agreement. Often there are similar provisions, in both types of agreements for management obligations, capital calls, potentially buy-sell provisions. So depending on what's in the shareholder agreement, if a shareholder does breach, it just depends on the remedies of the agreement actually provide for. However, often within buy-sell provisions, assuming we're asking the question within buy-sell provisions, there's another question too. Basically, often the buy-sell provision will indicate a forced sort of forced buyout. So if the person or the estate or the spouse does not actually go through with this, so for instance, your partner and you're trying to buy the other person's shares, spouse's shares, maybe their spouse inherited it in the event of a death, and they do not want to abide by the buy-sell provision. A lot of times the buy-sell provision can force, actually indicates there that in the event that the party does not go through with this, with the procedures that have been set out in that provision, the company becomes an automatic attorney in fact, or basically a power of attorney on behalf of that third party that can sign all these agreements, basically. Those type of provisions should be there so that it can be enforced. And of course, often there are attorney fees provisions that in the event in these agreements that someone does not cooperate, including third parties, and you're required to enforce the agreement and go to court, often the prevailing party will be entitled to attorney fees. That's something that should also be in these agreements as well. Now, another question we had is, what are my legal options and how much would litigation approximately cost? This is from the same person that asked the default on the shareholder agreement. So presumably, if you're trying to enforce one of these provisions in the event of a creditor situation or death situation or circumstances, basically you would, it's not a full, hopefully you're not litigating a lot of other issues, assuming you're just litigating this issue. And if it's in probate, it could be anywhere from 5,000 to 7,000 to 20, 30, 40, 50. It's really hard to tell. It depends on the type of company and the amount of partners, the amount of things that might be in dispute, but it can be very costly and particularly very time consuming and take you some time to actually get a response. Okay. Actually get a ruling, basically. Often litigation in these kind of situations can take years. More than often than not, I find they take anywhere from 12 months to 18 months, but it's still a very long period of time to be left in limbo. And often the partner that may have suffered a disability or the estate that has a death, they need the money fairly right away, or they need certainty. But if it's them actually defaulting, that's another situation. But the company doesn't also need to be tied up with this potential liability. So it's just better to have an agreement that clears out what each party's rights are. Here's another agreement. In drafting a provision addressing deadlock situations, what would be the most effective, most efficient and cost-effective way to resolve a deadlock? Well, there's probably 100 different ways potentially you could write a deadlock provision. However, one of the most cost-efficient and effective ways to do so is that you determine a valuation of the company, fair market value, how an independent appraiser is going to use, or what methodologies that they're potentially going to use to find a fair market value of the company in the event of any of these circumstances. And of course, fair market value is as of the time, when the circumstances occur, not maybe 10 years before when you had signed the agreement. But potentially, it's just very straightforward. We have a dispute. We cannot get along anymore. We have tried to, sort of mediate. Maybe have a mediation provision there to try to mediate a dispute you have with each other. If the mediation fails, you could basically do a put. Either you require the other person, you give them an offer, they buy you out right then and there, or you're automatically given the right to buy them out if they do not exercise their right to buy you out. And of course, it'll be at the fair market value, which you guys have already determined. And then, of course, if something does not, if neither party can actually purchase the other out, maybe there's another provision because they don't have the actual money to. But this is where a promissory note actually comes in handy, because if you indicate the promissory note can be used in the buyout of another party, potentially that can help one of the parties afford to buy out the other party, but they may not want that. They may want cash and they may not agree to those provisions. It would be basically to sell the company. Okay, that's one of the ways to just, if it doesn't work out, a put or a call, basically, then you just force the sale of the company. So one of the other questions is, what do you do in the instance where business is worth more than it has in liquid assets, so buying out a partner would not be feasible? Sorry, I was actually partially answering that question in the previous question. So what you may do if they can't buy out the other party's interest, or there was not an agreement to use a promissory note to purchase the other party's interest, then you would just, the provision should indicate that the company should be sold immediately. And my suggestion, if it's sold immediately, that it not be sold under duress or for a fire sale, because you're going to get a lot less for the company. There should also be a confidentiality provision in place that, basically tries to keep everyone quiet so that the market doesn't understand that there's turmoil, because they will also, the company will become devalued as well, unfortunately, or you'll get some low offers because they knew you guys were in a bad situation. So that's all for the questions. Hopefully I've been been helpful. This information. If we can ever be of assistance to you, or you need help with the buy-sell agreement or anything related to corporate law, please do not hesitate to reach out to us. And hopefully this has been informative. Thank you very much. And once again, may the force be with you. And hopefully you never end up with a partner like Darth Vader. Okay, everyone take care, and we'll see you sometime. We'll see you soon. Bye-bye.